For over 2 decades, domestic workers were excluded from the protection of the Compensation for Occupational Injuries and Diseases Act. Have they overcome this challenge? Well, we'll find out on today's show. Workers' World starts now.
From England to Poland, every step across the ocean, the ruling classes, them is in a mess. Oh yes, the capitalist system of regrets.
Welcome to the weekly Workers' World Labour Show. I'm your host, Tashirik Trubody. Thank you so very much for joining us. Domestic workers have historically been at the heart of the reproductive labour required by society and the economy. The vast majority of domestic workers are women, and their labour remains grossly undervalued. They have been part of the struggles for several decades and in South Africa to secure workers' rights, and while being conditionally included in the LRA and the Basic Conditions of Employment Act, they were excluded from the protection of the Compensation for Occupational Injuries and Diseases Act, COIDA, for over 2 decades. In today's show, we learn more about COIDA, the victory of the domestic workers, now being covered by its impact. But first, let's go to today's insert prepared for us by the Workers' World Media Productions editorial team.
Phakathi asangaphezulu wathatha le uthena ayibambile yamwela yamthelile then kwi-chemical strong uthena ke hlawo nje akasabona ujahela ukuthi uyogeza then walimala kanjalo ke then ilinye ilihlo lagcina alisabona.
When I read about the case of Maria Mahlangu, it was not the first case that I heard about of a domestic worker who died on duty. There was a case of Mama Mngadi in KZN. There was a case of Christina Moyo in Alexandra. When it was Maria Mahlangu, I said now it's in Pretoria, because I know that the domestic workers were not given justice, and they were not taken like other workers. They were discriminated, and I knew that something was wrong and somebody has to do something, and that somebody was me. So I started. It was not an easy journey. I remember I was turned back. Many doors were closed on our face because I was going up and down with Maria Mahlangu's daughter Sylvia. So yeah, it was a challenging journey until Solidarity Center intervened and assisted us in getting lawyers to represent us at the Pretoria High Court up to the Constitutional Court.
Omunye usara mako uthi bekathi beka atlina ku safe yakhe lahlala izinto zokusebenza, so uthena kabamba elinye ibhodlelo kodwa uthi chemical yakhona i strong nje bekaphezulu laphezu kwe steps, so uthena kayisusa ukhosi beka shift athatha lezi eziphakathi azisanga phezulu wathatha le uthena ayibambile yamwela yamthelile ihlo then kwi chemical strong uthena ke hlawo nje akasabona ujahela ukuthi uyogeza then walimala kanjalo ke then ilinye ilihlo lagcina alisabona.
To have domestic workers included in COIDA is an insurance that domestic workers never had before. It brings hope to the domestic workers who were also injured in the past on duty, as it applied retrospectively to 1994. But really, this is a victory that it's a landmark case and a victory that we will never forget in the history of domestic workers.
Angizwa nje bengisemsebenzini and then saphinde sazizwa sihlangene sonke la kudosa emithinini. Ngajabula kakhulu ukuthi at least okhunye kuyachubeka kuyenzeka usesipinki asenzela khona. Basasifundisa kodwa yonke into ihamba kancane. Sisafundiswa ngakho ukuthi sazi nje ukuthi nasilimele fanele senzene singena kuyiphi iminyango.
I think it's great that workers won that, the domestic workers won that. The issue is going to be, the implementation. And there are several problems. The one thing is just how familiar workers are going to be with that right. We face that same problem with labour broker worker rights.
It is more the case that there's a big delay between the submission of the completed forms and the actual benefit that the injured worker and his family or his family may get, you see. So I think these delays are difficult. Then also, because of the centralization in the past, I think there's some decentralization now. Inquiries took a long time. It was very expensive for people to phone and find out. And literally, I know I could sometimes spend a day engaging with the Compensation Commissioner's office to find out about claims and so on.
Because the compensation fund is like an insurance, the employer has to pay a levy every month into the fund. And once the commissioner finds that the injury or fatality rate are extremely high at a particular workplace, then they up the employer's insurance or levy. So I think it is beneficial for employers to hide that type of information from the commissioner, but it's not benefiting workers.
So for us, it is a breakthrough for domestic workers, and like the domestic workers that was saying at the ILO, today we've got back our freedom and our dignity. Don't let us lose it again.
Well, there we have it. COIDA progressive in its nature, but very serious challenges lie in terms of access, not just to the legislation, but more so access in the spirit of that legislation. We'll get into that and more after the break. So there we have it. Quite a progressive in its nature, I believe, but access to it certainly have been a stumbling block because not all workers at some stage qualified, to the point where you might recall recently there was a constitutional court attempt which ruled in the victory certainly for domestic workers that they too are eligible because where they are is indeed a workplace. And the spirit of the legislation is such that it does cover injuries in particularly that had been attained while being at work. So for domestic workers in particular, this has been a great challenge to the point where it had to go to the Constitutional Court. And so that is what our conversation is about today. And let's now get into that, the conversation with Ikram Baks, the head of compensation fund for the Western Cape Department of Labour. We also have Vanessa Leroux, the health and safety officer for NUMSA in the Western Cape. Joining us shortly will be Pinky Moshane, the president and founder of the United Domestic Workers Union of South Africa. Ikram, thank you so very much for your time. I'd like to start off with you. To describe in its essence, what is COIDA? How does it work?
Thank you, Tashriq. I think let's start off by saying that the Compensation Fund is a public entity of the Department of Employment and Labour. It receives its mandate from Section 27 of the Constitution of the Republic of South Africa, which basically says that all South Africans have a right to social security. So the fund actually administers the Compensation for Occupational Injuries and Diseases Act, or COIDA, as you've correctly said. The main objective of the act is to provide compensation for any disablement caused by work-related injuries or any disease that's sustained or contracted by the employees, or even for death resulting from injuries or diseases. So in essence, we are responsible for the provision of compensation, of a pension, of medical benefits, as well as rehab services to any employer who is injured at work or contracts a disease at work.
How does the fund, to stay with you, Ikram, how does the fund generate its money? Of course, if an employee were to unfortunately find themselves in such a circumstance, there need to be money available. So I'm quite curious to understand who makes the contribution, and is it based on scale, on what the income is of the worker?
That's correct. It is. It's based on assessments that are raised from all employers in the country. As per the COIDA Act, all employers are obliged to register with the fund as an employer, and then on an annual basis to submit a return of earnings. And that's the funds that contributes to paying medical benefits for all injured workers or those who contract a disease.
But
so it's not taxpayer, it's actually assessments raised.
Is the onus on the or the employer to make that contribution? Because some of the challenges that we found in the last 2 years of COVID would be that employers had not been paying UIF funds of employees. So when it comes to COIDA and the commitment to that fund, on whose interest or on who takes the responsibility in the payment and contribution to that fund?
Legal obligation is on the employer to pay the assessments on an annual basis.
Okay, and that's important to understand, because I want to get into this now with Vanessa Leroux, the Health and Safety Officer for NUMSA in Western Cape. It's something that is seen as somewhat progressive in the event. It's almost an insurance for the worker at the workplace. But the reality is it didn't apply up until recently for domestic workers. Give us the background, Vanessa, on why this was a fight for domestic workers. Right, we'll come to Vanessa very shortly and go Okay, there we go. So I was asking in regards to domestic workers, why it appears this was a fight for them.
The domestic workers for years were not covered, and 11 years ago, litigation has started with a domestic worker that drowned. And only then, when the family took this matter to court, has the court ruled that domestic workers should be included. But it's been a struggle for many, many years with many, many protests from the different domestic unions in the country.
Yeah, before I go to a break, Pinky, very quickly, just your initial reaction to COIDA and how you see the implementation of COIDA. Do you think it's progressive for the worker? Pinky Moshane? Yeah.
Good evening. Yes, COIDA is something new to domestic workers. As we all know, that domestic workers were not covered until the case of Maria Mahlangu. So far, the Mahlangu's family has been compensated by the government. So we can say there is progress.
Yeah. Well, I want to get into that is what it is that we can say to try and understand the extent to which it's going to be implementable and scalable for domestic workers and other vulnerable workers as well.
And there are some few cases that
All right, this is the Workers' World Labour Show. Thank you very much for being with us. We're discussing a very interesting subject today, in that we're asking questions around access to workers' rights, fundamentally when they do get injured at the workplace. And that, of course, is the COIDA Act. And in this instance, we've been talking a lot about domestic workers that seem to not have had access up until it took the life of a domestic worker that fell into a pool, and a very progressive order there by the Constitutional Court that now gives domestic workers access. But I want to broaden the conversation a bit more now to look at how COIDA is applicable even before that terrible tragedy, and whether at the moment it has problems, as you know, Karama was saying with earlier, some of the administrative challenges and the reforms over the last couple of years. But Vanessa, broaden this for us. How has COIDA been implemented in a more formal setting, for instance, like steelworks, within mining operations, etc.? Is COIDA proving to be a useful tool as a fallback in those instances?
With respect to Dr. Bucks, most of our mining industries and iron and steel gets administered by the Rand Mutual Insurance, which basically works for COIDA. It's an independent insurance company that manage the injury on duty cases. With them, we have very good turnaround time. With the Department of Labor, we seem to have still very, very much problems with our old cases. Although the systems has been improved, if you don't follow up on a case, that case lays dormant. The Department of Labor or COIDA compensation fund has to import that case, and then documents are lost. We then have to get medical reports or final reports, then back to the Department of Labor. The other problem we still have is that since COVID, accessibility has been very, very bad. In terms of telephonic follow-ups on cases, there is just no answer.
you have to go now physically in. What I recently, I think it's a big joke, what I recently discovered is the emails that I personally send to compensation fund. Somewhere in cyber, somebody said, no, ignore that thing. We'll never receive it. Just bring the documents into our offices. So those are the administrative challenges that we're still sitting with in terms of submitting outstanding documents. Or
can I ask Vanessa, what is the typical frequent type of injury that you would be submitting a claim for?
The frequent injuries would be back injuries in our industry. It would be cutting of fingers. It sounds very blunt now, but loss of limbs. Let me rather put the proper word. Loss of limbs, loss of fingers, loss of... basically, those are the typical injuries. And then the diseases that we typically have is asthma, silicosis, manganese cases. Those are the typical cases.
Yeah. And so, Ikram, do they vary? Because, I mean, a silicosis case, I know you're here in the Western Cape, and there's not a great deal of mining that happens compared to Limpopo, Mpumalanga, Gauteng, where there's a greater proliferation of that sort of industry. But maybe you can also kind of answer the same question about what sort of injuries are typically, admitted to the application that's given to the department. And more so, you spoke about the first medical report, and this, of course, is a follow-up medical report. I'm sure depending on what type of injury or disease we are talking here about, an application can be delayed, again, depending on the context and the nature of the injury.
Yes, thanks, Tashreeq. I think Vanessa gave a perspective from her current work environment. With us in the Western Cape, we see a wide range of injuries and occupational diseases. With specific reference to domestic workers, for example, it's still early to provide a list of common conditions that we see, because it's quite new to even pick up a trend of what are the common injuries. But I think if you look at international literature, the domestic workers in private homes will encounter quite similar hazards to those that are found in the health sector. Vanessa spoke about falls and cuts and bruises, which will be quite common. But with domestic workers, I think the other common injuries will be musculoskeletal injuries, resulting in chronic back, shoulder, arm, or leg pains, or repetitive motions, or lifting of heavy objects, lifting of children, for example, or if they are caring for any dependents in the household, sometimes lifting those heavy dependents can also cause injuries. And then on the occupational disease side, exposure to cleaning chemicals will be quite a common injury we will expect among domestic workers. If they are exposed to any member of the household who has TB, or in the recent past, anybody who has been exposed to somebody with COVID-19, and they had direct contact and contract COVID-19 occupationally, then they may be eligible for benefits for the occupational COVID-19.
And that's what I wanted to just quickly stay on, because of course you're a medical doctor as well, and I want to understand what happens, because there are different circumstances. There could be a viral infection such as COVID-19. There could be a scenario where perhaps the domestic worker was negligible in how they did their work, or there could be a scenario where the employee would have to think about whether the domestic worker needs to be incapacitated because she can't lift the child because she has a historic back problem. Are there mitigating circumstances when an application is filed to say, let's take into consideration those sorts of elements before we decide to pay? And could that disadvantage the domestic worker?
Yes, when we assess a claim, we do look at it holistically. So it's not up to the employer to decide whether something will be compensable or not. So the employer's responsibility is only to report the claim and tell us what happened. The medical doctor will certify whatever physical injuries that are found. And then when the claim comes to us, the claim is registered, a claim number is obtained, and then we go through a process of adjudication to see whether to accept liability or not. And once we accept liability for the claim, in other words, it's a legitimate claim for an injury that arose directly out of the course of the duty of the employee, then we will start to pay benefits, which will include access to medical aid, medical benefits. And if the employee is booked off for 4 or more days, then we will compensate them for loss of income. We pay what's called temporary total disablement.
Pinky Mashiane, do you know of instances where applications have already been filed for compensation, and what has been the experience there? All right, Ms. Pinky, can you hear me? I'm asking about whether you know of instances where an application had been filed and what was this experience?
What I'm saying is that there are challenges with domestic workers, more especially because the Constitutional Court ruling applied retrospectively. Some employers have relocated, while we have the other employers who have passed on. So it becomes very difficult for domestic workers, because at the Department of Labor, they are saying that the employers are policyholders. The employers have to fill their forms. That's the challenges that we have. And I must say that this COIDA is long overdue to domestic workers. Domestic workers have been affected by all forms of injuries at work and all of illnesses. Domestic workers fall from step ladders, cleaning windows and washing the walls. Domestic workers they are sleeping in their house and break their limbs. Domestic workers are beaten by dogs at workplace. Domestic workers, there are those who are killed while looking after the insured house of employers while their lives are not insured. So domestic workers have been exposed to all kinds of work-related injuries and diseases for many years. As I'm saying to you now, we have many cases that happened the past years, and we still have to find the employers. We tried others, we don't find the employers. They have moved to other places for domestic workers to go and claim from COIDA. With the new cases, you still have challenges. I have a domestic worker who was injured recently. When we gave her forms to give to the employer said to the domestic worker, if I fill this form, I'm the one who's going to get money. I even called the employer and explained to him and about the case of Maria Mashangu, and that how it came, and who am I in that case, that I am the person who brought this case up and who made sure that justice is served to domestic workers who are injured and died on duty. So the employer filled the forms after that.
Okay, and I want to talk about that once we return from the break. When a payout then happens, we've been talking a lot about the process as well. When a payout has been actioned, who gets that money and who gets to get access to the money? We'll get into that conversations once we return from the break. Do stay with us. All right, it's the Workers' World Labour Show. Thank you very much for being with us. We're having a fascinating conversation about access to recourse in the event that you do get injured in the workplace. And we've been talking a lot about the fact that there was a segment of the working class that had not been included, and the realities that come with the fact that when they do wish to apply, there are very real challenges in the administration of a fund that's meant to protect the workers in a very progressive way. So this has been our conversation, and I want to now look into the element and about what type of worker then is considered, as part of this sort of umbrella cover that we have. And maybe, Ikram, Dr. Ikram, just to come to you, whether the legislation in its current form is only applicable to certain segments of the employment sector, or whether by definition anybody that works for a boss is covered by this particular act.
Yes, Tashrik, I think the definition of employee in this country has also evolved, because the Labour Relations Act defined employee as any person, excluding an independent contractor who works for another person or the state and who receives any form of remuneration. And then the Basic Conditions of Employment Act use the same word, but in the COIDA Act, an employee was any person who has entered into a contract of service or apprenticeship or learnership with an employer. And that contract can be in writing, or it can even be verbal. And now recently, the definition, as you've heard from the Constitutional Court ruling, the definition of employee has been expanded to include domestic worker. And I think what's important for the viewers to also realize is that domestic worker includes It includes gardeners and butlers and drivers. So they are all covered now under the COIDA Act.
So somebody that works cleaning a pool but works at a home working for an employer, in that instance, or a driver, a gardener, a cleaner, somebody that works for a period of time consistently would be able to be covered by this particular fund.
Correct.
Okay, that's important to know, because that, Ms. Mashiane, it does then broaden the scope of what we think to be domestic workers. It isn't just, the auntie and the go-go that cleans the home and looks after the kids. It's a bit more broader than that.
Yes, yes. It includes drivers, like it said, that drivers who are driving in a private home are domestic workers, those looking after babies, the nannies, looking after the sick and the aged. If it's in a private house, are all domestic workers, those people.
Okay, and so I'm wondering, Vanessa, whether you think there's an appetite here. I know you don't necessarily work in the sector, but you organize workers traditionally. I suppose one of the challenges now would be to orientate employees and employers about the Act, the purpose of the Act, and how to register and all of those sorts of things, and ensure that when an employee is injured on the job, that he or she knows that there is some sort of recourse.
Yes. Yes, I think the orientation is very important. Funny enough, I saw in KZN on the airport, there was a poster from the Department of Labor advertising or saying now domestic workers are covered, and those other workers, gardeners, etc. But I think, like Pinky said earlier, a lot of work still needs to be done. By either us as trade unions to conscientize workers, to inform them they have this right now, and I think by the government to inform workers, either by road shows or like these posters everywhere, that those workers that were previously discriminated are now covered.
Yeah. Dr. Kiram, you want to come in there?
Yes, I agree. I think the domestic worker sector has always been quite a vulnerable sector, and they experienced many challenges over the last few years, including being excluded from labor legislation. But other than that, they also experience other challenges, including job insecurity, low wages, poor working conditions, long working hours. And now that we have one of the most inclusive definitions of employee, they can access the full range of services that the compensation fund can provide.
Dr. Kiram, I want to stay with you. How proportionate would the compensation be to the loss? Yeah, I mean, again, it depends, I suppose, on the varying circumstance of the disease or the injury. Because if I severed a limb, or I have a back injury, or I fell and I needed to go to the doctor, I'm just wondering whether we're looking at sort of 100% cover scenario comparable to the proportionality of the injury or the disease.
That's right, Tashrik. I think the compensation is proportional. There's no difference in the compensation that's awarded to the domestic workers as opposed to any other employee. So, for example, if an employee gets injured and a claim is accepted, the fund accepts liability for the claim, we immediately will pay reasonable medical expenses. The second benefit that they will be entitled to is temporary total disablement, which simply means we will compensate them for any loss of income if they are booked off for 4 or more days. And then when the medical condition or the injury has stabilized and the patient has reached what we call maximal medical improvement, the doctor will issue a final medical report, in which case we will finalize the claim. And when we finalize, we will determine whether there is any permanent functional incapacity or permanent disablement, and we award a particular percentage to that disability. Oh. And then they will be compensated commensurate with their earnings at the time of employment.
Okay, and I want to come back to you, Ms. Pinky Mashiane, about the experiences and the challenges that you have right now, and that is an instance where an employer would have made a claim from the fund, but then saying the money is being taken by the employer. What is the justification in those instances? And I want to come back to Dr. Karam just now about where the money gets paid and to whom the money gets paid, but give us some background into this current challenge that you're currently experiencing.
I don't think that's going to happen, that the Department of Labor can pay the money of the injured worker to the employer. They have to communicate with domestic worker in person, not the employer. The employer is just to fill their forms and give the relevant information to the Department of Labor. And the domestic worker has to do the follow-up until the fund is paid. There's no way. That will be corruption if the money can be paid to the employers.
Okay, but Dr. Karam, I mean, we're sitting with a sector here where I'm not sure whether, because there's a big segment of the market that doesn't have people that are banking. They're not a customer of a banking institution. They do not have banking accounts. So when monies are paid out, how are they traditionally paid out? I'm just worried for a sector where the person get 150 rand a day to come and clean the garden or be the domestic worker. How do you process those applications, and how does the compensation happen?
Just a point of clarity. Firstly, when we compensate for loss of income from day 4 of being booked off, it's a responsibility of the fund to cover that loss of income. So if an employer chooses to continue paying the salary of that employee, then we will reimburse the employer. And if the employer stops the salary for whatever reason, then that money will go directly to the employee. But you're right. There may be many circumstances where the employee will not have a bank account. Unfortunately, with the current system we have, we can only pay into a verified bank account of the employee. And I think those are control measures that we had to have to minimize or to eliminate the possibility of fraud or corruption. So there are instances when the money can be paid to the employer, but that's only if he or she continued to pay the salary for the employee.
It's an interesting challenge, which I'm wondering, Vanessa, if you have any thoughts on, because again, progressive legislation, progressive frameworks, but very real challenges.
Yeah, you know, COIDA makes provision that legally the employer is obliged to pay for the first 3 months. And the employer then claim back, or compensation fund pays the employer. In the domestic worker scenario, I can understand Pinky's reservations around this issue. Will the employer pay? There will be corruption, fraud. That is a situation, I think, that needs to be tightened. But we haven't had difficulties where employer paid the employees and they claim back from the compensation fund. We even go further to try to fight when we find out there's been negligence on the part of the employer, that they continue beyond the 3 months, because it's much more easier because the person is on the payroll. If the domestic workers were in a situation where there is a regular payroll, then it should not be difficult. But they would have a challenge because it's the individual worker, and their method of payments are sometimes also not like the workers in the traditional formal sectors.
Yeah. We're out of time, Vanessa. Thank you very much for that. Ms. Pinky, I'm going to wrap up with you very, very quickly in a couple of seconds. What message do you have for employers and employees, in particularly the domestic working sector, to say, get registered now, pay your dues and your obligations, and for workers to know that they have this level of protection? Very quickly, Ms. Pinky.
Yes, what we are going to do, the 16th of June is International Domestic Workers Day, while it's Youth Day in South Africa. We are going to march in Pretoria to the Department of Labour, Laboria House, to raise awareness about COIDA. We want domestic workers to know about COIDA. We want employers to know about COIDA. So our message is domestic workers have to find a way to communicate with their employers, or even to come to us and associate themselves with us, because if they are one by one as individuals, they will never know about their rights, and it's easy to exploit them. So we will send out the message and invitation, the pamphlets, telling domestic workers about COIDA and even about our march on the 16th of June.
I hear you. Thank you very much. 16th of June, Workers' Day, particularly directed at domestic workers. Thank you very much on that note for having joined us. Indeed, I wish to reiterate progressive legislation, progressive cover for workers, but very real challenges remain. And for now, it is a situation where indeed we need to ensure that workers unite and indeed do not starve. Thank you very much for tuning in.